Please be seated. Good morning. To my right is Judge Catlett. To my left is Judge Cruz. I'm Judge Weinsweig. We are here today for oral argument in case number CR220302, State v. OSGOOD. Each side has 20 minutes for your argument. This morning, the appellant may reserve some time for rebuttal. I would just ask that you keep that yourself. There's a clock on the podium. Our proceedings are being audio and video recorded, so if you would introduce yourself and your client who you represent at the outset, that would be much appreciated. We've read the briefs, discussed the case in conference, and are familiar with the arguments raised. So if you can keep that in mind when making your arguments. And with that, counsel, you may proceed.
Thank you. Good morning. May it please the court. Molly Briskus on behalf of the appellant Ethan OSGOOD. And I'll try to reserve a couple of minutes to respond to the state's argument. I want to first talk about probable cause in the digital age, and I'm framing it that way for a specific reason. I don't think law enforcement or the courts are sufficiently contending with the digital realities that are posed when there's membership, affiliation, or to a digital service. I want to give some examples. It's very common to have a single email address for a business where multiple people have access to that email. You take a Netflix membership. There's multiple people that are under that umbrella membership. My sister-in-law is on my family's T-Mobile plan, but she lives in California. I recently stayed at an Airbnb where the previous occupant had logged into the television platform, so it was me watching the World Cup, not that previous occupant. These are just some of the examples of this kind of what I'm going to call digital affiliation or subscription, and these are not the exception. These are commonplace.
And counsel,
Yes.
To be sure, in this case, we're talking about two people having access to one IP address, right?
Yes, I think that's important. That's one factor that I would like the court to keep in mind. Also, there in these types of cases, there are what's called open wireless networks where people from neighboring homes can access these IP addresses if they're called open
Was this
source.
an open network?
The law enforcement didn't conduct any sort of analysis about that, so we don't know whether or not that's the case or not.
I guess at the suppression hearing, was there evidence that this was an open access network?
No. No evidence was
Either way.
Right, either way, it wasn't. And I think that's, I think that, the court kind of is looking at the kind of historical precedents like Pringle, where you're talking about real human beings together in a car in a joint venture. I think that historical case law must yield to these realities in the digital age, that and the court should look at what these affiliations do and do not reveal about our relationships and our real selves in the real world. The IP address point that you bring up, I think that's really important. One of the state's best cases, I think, is this McCarty case. In that case, the police did do some additional steps where they had determined that the defendant lived alone, so there weren't other people accessing the home, which is not the case in Mr. OSGOOD's case, and they had done that additional investigatory step of determining whether there were open wireless networks that someone could access it. State v. Ryan is another case that the state cites. That's an Ohio state court case. In that case, you see law enforcement doing some additional steps to narrow down their focus to probable cause as to a particular person. In that case, they conducted 6 to 8 hours of surveillance on the house for an entire week. They had determined from that surveillance that there was only one person coming and going from the house. The defendant lived alone, and they tested the wireless network from various devices, an iPad, a computer, a phone, to determine that there was not an open wireless network such that someone else could be accessing that IP address.
So in a case such as this, where you have two people living in the home and you have information that one of them works in some sort of emergency medical service, and there's a male and a female, and the information we have is that one of the email addresses is legal-CPR, and one of the identifiers is gent, which could be short for gentleman. Why is that not enough to focus on the male of the two residents in the home?
So I think the evidence that the police had at the time that there were two, that Mr. Osgood and his girlfriend lived there. Also, his daughter lived there, as well as who was a teenager, and that she had a boyfriend that came and went from the house as well. So there's kind of more permeable movement in this house than I think in some of the other cases. But I think if you look at the email address, legal CPR, I think that's a generic email address that the state is asking to carry a lot of weight in this probable cause analysis. I think if the email address was Ethan Osgood or something, a specific name, then that may be different. But this is a generic email address where one of the verbs legal was could be associated with Ms. Kolar, I think, or CPR could be associated with Mr. Osgood. The evidence at the evidentiary hearing never even linked. There was no determination of what that email address actually was ever linked to, and whether or not it was linked to Mr. Osgood or Ms. Kolar.
Well, what's the standard? Is absolute certainty required?
No, definitely not. I mean,
what's the standard?
It's a common sense balancing of factors. We're not trying to say that it has to be absolute certainty or, beyond a reasonable doubt. But I think that it has to be, that a crime is being committed by a specific person, by a particular person, which is why I think the Pringle line of precedents are just not applicable. This was an investigation that was building. In Pringle, the officer was witnessing a crime in front of his eyes. That is not the case here. Detective Brazil and Detective Barker talk about how this investigation was building to try to determine who accessed the computer that had downloaded the images. I think it's, in this case, both of them talk very frankly about how difficult these cases are to prove because you're not able to see who's actually physically, on the computer at the time. So you have to use these other investigatory tools to try to get at what that is. I think in terms of probable cause to search the house, that is very different than who did it at the house. And I think in some of the other cases...
And I think the state makes the comment at one point that Mr. Osgood concedes that there was probable cause for purposes of the search versus probable cause for purposes of an arrest. Do you agree with that statement?
Well, I think that's a little bit complicated because the search took into account the NICMIC searches that we also have an argument were unconstitutional. So I think, looking at the search warrant, on its face without kind of contending with that, I think there was definitely, under the facts that Detective Brazil swore out, there was probable cause to search the residence where the ISP address was linked to. But I think that Detective Brazil and Barker talk about how that is different than probable cause for an individual. And I think that's why they didn't get an arrest warrant for Mr. Osgood at that time. If they thought that they frankly said on the record, we didn't think we had probable cause to arrest him. So I think they're different. I think, locus, to search a locus, a physical house associated with ISP address, very different than the particular person in this situation. If you don't find that there is probable cause, I don't think the confession was sufficiently attenuated. I don't think there's any way the state can argue that here because of Brazil's frank admission that he did not think he had probable cause.
But is it a subjective or an objective standard?
Well, I think in the attenuation analysis, you're looking at whether one of the factors is that you're looking at whether the officer's actions were flagrant. And you're looking at whether Mr. Osgood's confession at the station was sufficiently an act of free will. The factors kind of get you at that analysis. And Officer Brazil told him in his office, well, the deal is I got a search warrant for your house, your vehicles, and yourself. So you're going to be going with us today. That was not true. He did not have an arrest warrant for Mr. Osgood. He misstated that to Mr. Osgood, and that was the opening statement when he walked into the office.
But with respect to probable cause, that's an objective standard. And so I guess what role, if any, does the detective's later statements or admissions that I don't think I had probable cause, what role should that play in our analysis?
Well, because it's this squishy analysis of kind of what, the factors of making a on-the-ground judgment of whether you have sufficient evidence. And I think that officer who was on the ground conducting the investigation saying, I knew I didn't have probable cause for the individual, which is why I went and I wanted to get a confession for him. I do think that can kind of, come into play when you're considering, especially when you're looking at McCarty and some of the other cases where the investigation is building and doing more, and we don't have that here. I want to point out, this issue with the NCMEC reports and this private party situation or search. I think this court has a benefit of, several circuit court decisions now kind of weighing in on this and thinking about this. One of the things I want to call to your attention is that, the Fifth Circuit's decision in Reddick, which the state relies on, really thought that, it found it compelling that the ESP, which is the Google, the chat step, that they have categorized this content in some sort of, A1, A2 categorization of contraband. And so that then on the back end, when the law enforcement is looking at it, that really it's this kind of binary test of contraband or not contraband, because the ESP has already categorized it as contraband, and so it's more like the chemical test in Jacobson, where you're not really revealing anything further.
I was trying to figure out exactly where the private search argument gets you. Because at trial, the images that were actually introduced were not the images that were attached to the reports. They were the images that were pulled off the computer at the residence, right?
Well, that's what the state has said in their, I think there was a question about that, and the trial court was confused about, following the thread through of, which images formed the basis of which counts. Putting that aside, I do think that some of the images formed the basis for the warrant.
Right, and that's what I was going to say. My understanding was your argument is that, well, for purposes of probable cause for the search, these images were used to support that, and if we think that the private search doctrine was violated, we should strike those and then redetermine whether there was still probable cause for purpose of the search?
Yeah, remand it to the trial court for them to determine whether there was still sufficient probable cause. I think either way.
Could we still consider the information in the reports, even if we don't consider the images that are referenced therein?
Reports, like the NCMEC reports?
Right, it describes, I don't know, the NCMEC reports conclusions that the images depict underage persons.
Well, so those reports I think they're equivocal on that. I mean, they have this categorization, one problem with those reports is they're kind of all over the place. They're from different ESPs, they contain different information, they're not answering a standard set of questions, and so I think that you can consider that, but I guess, one of the arguments that we think the trial court erred is reading too much into those, because we don't have testimony from Google or ChatStep or whatever ESP about what they meant when they said what they did. Sergeant Barker and Sergeant Brazil both say, though, that they often get reports, chats, NCMEC reports that are, say this is A1 contraband, and then they open it up and that is not true. So in terms of the Reddick kind of line of reasoning of this is just a binary test, contraband, no contraband, chemical test, that is belied by the testimony of these officers in this case. Sergeant Barker said, I've had cases in the past where it comes back as child pornography, and when I open up the video and look at it, it's an adult woman, or something. There might be some type of mistake made. So that's why he says he's not taking his categorization as gospel. He is making sure, that's why he has to open it up, search it, look for himself.
But isn't that what the ESP has already done?
Well, it depends. I mean, some are doing hashtag matching. They're not looking at it at all. I think that's one of the big factual issues in this case is what exactly occurred with the ESP. Each one. I mean, each of these NCMEC reports has a different ESP. What exactly they did, and I think the devil.
So we don't know based on the record whether this was a hashtag search or whether a human being actually reviewed these images at the ESP?
Well, so what the trial court said is there's a one line that says, did the company review the image? On some, I think on 2 of the NCMEC reports, there's that verbiage, and it says yes. On the other ones, there is not that verbiage. It talks about hashtag matching and photo DNA.
And what do we do with the fact that it seemed like Mr. Osgood's own counsel, at least at one point, was taking the position that someone at the ESP had reviewed these images?
Well, I think, after the evidentiary hearing in April, when the parties, it wasn't a true evidentiary hearing. It really was the lawyers discussing what they thought occurred with exhibits that had been submitted to the judge. And after that, the defendant filed a pleading contesting, it was fashioned as a motion in limine, but it said, the state has not called anyone from the ESPs to establish what happened here and objected to their admission at that point.
But then later stipulated the admission of those documents into evidence, right?
Well, no. So beforehand, in his motion to suppress, the defendant had attached the NCMEC reports as exhibits, and then those were submitted to the court for this, evidentiary hearing. The defendant never stipulated to what those meant. I mean, he allowed them to pass through the evidentiary gates and they were put before the trial court. But
so for purposes of foundation or hearsay, things like that, we're past that.
Yes, I think that's fair. They were admitted for those purposes. He did not ever, I don't think, that my friend on the other side might point out a place in the record where I have missed, but I don't think he ever said, yes, that this means that Google opened this, looked at it, and determined it was contraband. I'm going to reserve the rest of my time.
Thank you.
Thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, Kevin Morrow, Assistant Attorney General for the state. Picking up where we were just leaving off, at the evidentiary hearing, Mr. Osgood's counsel's argument from his motion to suppress was that the ESPs reviewed, actual people at the ESPs reviewed the images, and that because the ESPs were government agents, that was a search in violation of the Fourth Amendment because Microsoft did not get a warrant. The judge rejected that, as has every other court in this country, that electronic service providers are not government agents. They are private parties in these types of searches. In the NCMEC reports, which I did not know that was how that acronym was pronounced until now, so I learned something new. So in the NCMEC reports, only one of them does not have the language, was this image reviewed by the ESP, and that was the chat step report, and the judge made that finding, and I think correctly. The others, and I have exhibits.
And dismiss the counts that were based on that report, correct?
The 2 counts that were dismissed, it's slightly unclear from the record, those were the 2 images that were found on his computer and were also sent and received, and I think they were through ChatStep. They potentially could have been prosecuted, but the indictment had the wrong file name and the wrong date, and the prosecutor felt it was inappropriate to amend the indictment in the month before trial, and that's why the state asked to have those counts dismissed. There was a question, and in my brief it might have been slightly unclear, that the
So
judge...
we don't know whether we have the ChatStep images as a basis for one of these convictions, or we do?
It's not the basis for any of the convictions.
Okay.
So in my brief on page 13 in footnote 2, I cite to record, I want to say 220, that was the pleading that the judge asked for from the state. But in the exhibits for trial, which is record on appeal 239, attachment 15 is the forensic examination of digital evidence authored by Detective Brazel. That details the images found on his computer that correspond to the 12 counts with the file names and then with the directory location. So user/Ethan/@step. So that exhibit in the record provided the foundation for which image went to which count. And I think the images are located in a separate pleading on a disk in a separate folder in this court's record.
Can we talk a little bit about probable cause?
Sure.
Am I correct that the state is no longer taking the position that this was just a detention requiring reasonable suspicion? This was an arrest?
Correct. I'm conceding this was an arrest.
Okay.
But the officer thought it was a detention. And when he said he wasn't
The
sure...
officer also thought there wasn't probable cause, so I'm not sure that what the officer, I'm not sure that helps you.
Well, but I think the context of that, the rest of his statements, I think, matter. Because when he said didn't have PC for an arrest, when he said arrest, he meant taking to jail, booking into jail, and charging with the crime. And he did not feel he had enough evidence for that without first executing the search and or interviewing Mr. Osgood. So I think the officer's understanding of what is an arrest is different from the legal understanding of an arrest, which is a seizure, like what happened in this case. So, I don't think this court needs to give a lot of weight, or really any weight, to the officer's opinion. That's a legal conclusion. The trial court found that there was probable cause for the arrest based on all the evidence that I think Judge Cruz brought up earlier, plus maybe even some more. So I don't think that really means there wasn't probable cause.
McCarty was a one-person case.
True.
Pringle was a three-person case. There were 3 individuals in the car. Is this a 2-person case or a 4-person case?
So this is a 2-person case. The officer did not know that Osgood had an adult daughter until during the interview of Mr. Osgood at the police station. And then I have a citation for that. He said that in the July 6, 2018 hearing at page 71, that's somewhere in there, he talks about how he did not know that there was an adult daughter. He thought Mr. Osgood had a small child, or actually, no, he thought the girlfriend had a small child, which was actually Osgood's small child, which lives down in Phoenix with the mom. So the officer didn't know about the girlfriend, so at the time the search warrant was issued, the officer only knew of 2 people. The officer had...
Are we bleeding into subjective information again, what the officer subjectively knew or didn't know? Or?
Well, I think he definitely... he testified that he did not know that there was anyone else in the house other than Mr. Osgood and the girlfriend. And police aren't required to exhaust every single possibility, interview every possible witness, and exhaust every lead. I cite the Dale case for that proposition. And then you brought up the McCarty case, something I wanted to point out from that one. So Mr. McCarty lived in an apartment complex, and Mr. Osgood lived in a single-family residence on a lot that was big enough for outbuildings. And so I think that makes the necessity of the police looking for whether or not the Wi-Fi is password protected, I think that is less of a concern in this factual context than in the context of, I think, my apartment complex. I think I've accessed like 20 wireless networks, all of which are password protected. So I think that factual distinction between the two cases is very important, and yeah, there is no evidence one way or the other. It wasn't brought up. I would think if Mr. Osgood had not password protected his Wi-Fi address, he might have brought that up. So I don't think that should really weigh against the trial court's finding of probable cause, if that answers your question. Something else I wanted to clarify from the record. There was a couple of things.
What if the evidence was that 10 people lived in the residence?
Oh, then
The probable cause is about line drawing at some point. Where do we draw the line? If I think this is a 4-person case.
4-person, I think it's very tough. I don't think I would argue that if the officers knew, and there was evidence that they knew that there were 4 people living in this house, and here they had it wasn't just 50-50 between Osgood and the girlfriend. It was, they had the gent username for ChatStep. They had the legal CPR, which connects to his employer as an EMS instructor at the community college, and then as a former ambulance supervisor. I think that gives an individualized connection. In this case, with 2 people, that it was Osgood and not the girlfriend.
But if I think it's a 4-person case, it sounds like you're saying you would agree with me there was not probable cause.
Unless there was, very particularized suspicion here, I think there is some. I think if there were 4 people, that gets very hard. Probable cause is less than 50%, but it's still something. Sorry, there was something else I wanted to bring to your attention. Yes, so I
guess on the statements by the detective, how do we know as a court reading a cold record which type of arrest he was referring to when he says, I don't think there was probable cause?
Well, I think, as I said earlier, we're conceding that the officer arrested him, but I think that context is important to understand the officer's subjective state of mind. Should this court consider it? But I again, don't think the officer's opinion really matters. That might go more to flagrancy if this court found there wasn't, in fact, probable cause and was trying to address attenuation, but I don't think this court needs to reach attenuation because there was probable cause from the IP address. He owned the house. They did several drive-bys of the house. He had 2 cars registered at the house, and that's, I think, partly why they didn't know about the daughter. The daughter drove the Prius that was registered to Mr. Osgood. So they had determined that he actually lived in this house as opposed to if it was a rental, if it was an Airbnb. That would be a very different concern. So the officers here did an investigation to connect Osgood. Not only did he own the house and he was registered on the IP, that it seemed like he actually lived at the house. I think that was an important step that they took to establish probable cause. If there's no more on probable cause, I was going to talk about the cyber tip reports. So here we had, I want to say 7. I think there were 7 cyber tip reports. The ChatStep one does not indicate it was reviewed by a person. The other ones all do. The ones from Yahoo and Microsoft, they have the language that says, was entire file. Did reporting ESP view entire contents of uploaded file? Yes. And I cited 4 cases, including the case from Ohio, where courts have found, based in part or in whole on that the ESPs did, in fact, look at the images. There was something, and then here we know it was that the ESPs connected it from hash value because they have the very long hash number in the cyber tip report. I think it was you, Judge Catlett, that brought up what if we took out the fact from the warrant application that the officer had looked at the image. And because here we have that fact and we have the fact that the ESPs looked at the image, I did not argue this, but there is case law, and I can give you a citation, to United States versus Cartier, 543 Federal 3rd, 442. It's an 8th Circuit case. And in that case, there was, the court found probable cause when the affidavit relied upon the hash value of digital files which had not been viewed prior to the issuance of the search warrant. And so the 8th Circuit found that the hash value connection alone was enough for the police to get a search warrant for the house in that case. And I did not argue that in my brief because the facts support that both the officer looked at it and that the ESP looked at it, but that is where some courts are going. But this isn't the case to reach that question. And I argue that this court should just find the entire issue waived because this was not the position taken by the defendant at the suppression hearing. This was taken really in the motion for reconsideration. The motion in limine wanted to preclude the cybertip reports from trial and the images sent and received through the ESPs. The state really had little to no interest in presenting those, so they didn't contest the motion in limine on all those issues. So I don't think that actually preserves their taking a 180 position on a fact issue at the suppression hearing.
But I guess filing a motion for reconsideration is enough to preserve the issue, but it certainly might impact our standard of review or what we look at in terms of deciding whether the trial court abused its discretion or not. So to actually pose a question, how is filing a motion for reconsideration not adequate to preserve an issue?
Because the question there
For
becomes...
purposes of appellate jurisdiction, I guess.
Yeah, well, because the question there becomes, did the court abuse its discretion in the order denying reconsideration because there was no... I cite the standard for motions for reconsideration in the brief, but it's a good
Usually it's new
cause.
evidence or new case law or something.
Good cause is, I think, the standard. So Judge Napper found that the defendant had not asserted good cause to readdress the suppression motion. So really, I think that is the question before the appellate court is, did he abuse his discretion in saying there was no good cause to reconsider the issue? And then should you want to consider the issue, it's, did the judge abuse his discretion in finding that Microsoft and Yahoo actually looked at the image? Because I don't really see any way under the case law that if you support that fact finding, then all the cases, even the Ninth Circuit Wilson case that they rely upon, which I think is a deep outlier in the legal field on this question, but even that one says that that's enough under the third party exception to get a warrant.
How about the issue of whether subsequently sending the images to an employee at the county attorney's office and a nurse, whether that expanded the search in a way that was unlawful? Was that
I don't think
preserved?
I don't recall if that was argued. I don't really think that goes anywhere because once, under Jacobson, the Supreme Court case, once the expectation of privacy has been frustrated, the government is able to use the image. I don't remember, there's some broad language there about everything that the government can do in order to sort of further the prosecution for the contraband. We talk a lot about binary tests. And
So why send it to the nurse then if you're not, what purpose does that serve if you're not expanding the original search to get additional information?
Well, at that point, the officer has already determined in his training and experience that this is contraband, these girls are under 15 and it is pornographic. But it's just double checking, and particularly in ages of children, it can get tricky. The nurse wouldn't rate some of the images.
Is there a difference between looking deeper into an item that has already been exposed by a private actor as opposed to looking in new places or in other places?
I think there is a difference. I think once the police essentially have custody of contraband and there's no more sort of Fourth Amendment privacy interest, I think the police can kind of do whatever they want with it. Going to Jacobson and the I don't know, kilo of cocaine that they found, he did the sort of the field test to double check that, yes, it looks like cocaine and it's packaged like cocaine. Let's double check. So he double checked, it said, yes, it's cocaine. I think he could have taken that to a lab for further testing that might have a higher standard of accuracy that prosecutors might like for trials, which could have said, oh, yes, this is actually cocaine that's been laced with heroin.
Which is different from then saying, let's also search other places.
Yeah, as opposed to saying, let's go in and search all of the other packages that this person might have sent. I think that's a tremendous difference.
What if they searched other places in the image or the file, for example, metadata, to figure out how many times Mr. Osgood had opened it and, when he had done so.
I think that's fine. They've determined that this is a piece of contraband. The metadata is part of the contraband. I don't think there's any problem with continuing the search with doing that. Something my friend said, she brought up here the testimony of the detectives that they had in the past received cyber-tip reports and determined that it wasn't actually child porn under the statute. That's sort of the purpose of a binary test, to determine is it contraband, is it not. So I don't know why that really defeats the sort of general purpose. And here, the trial judge found 4 of the 10 images at trial to be not sufficiently pornographic under Arizona statutes. And there's 50 states. They all have probably slightly different definitions of what is unlawful child porn. And Microsoft and Yahoo might have sort of their understanding of what is inappropriate on their servers that they've identified as child porn, but might not meet the exact statutory definition. I think that's why I'm arguing for the officers can open up, look, and double check, as opposed to the Cartier case that I cited you, where it just issued a search warrant based on hash value alone. Any other questions? Seeing none, I'll rest the remaining issues on my brief and ask that you affirm the convictions and sentences.
Thank you, counsel. Rebuttal?
Just a couple of things. So I think Wilson, the Ninth Circuit case, is on all fours with Mr. Osgood's case. And Wilson, the court was concerned with the record in the case that had been made below, and I think we have the same problems with the record here.
I guess in Wilson, did you have a factual finding from the federal district court that the ESP had opened up and reviewed the image?
So the court was not, the Ninth Circuit was not sufficiently convinced that the record was flushed out enough about that issue for the state to meet its burden showing that the search was constitutional. And I think in this case you have the same circumstance. The state abdicated its responsibility and its burden to show the contours of the private search. At that hearing it said, we don't think we need a full-blown evidentiary hearing. This is a legal issue. There's really no facts in dispute. They could have put on evidence about exactly what the contours were of the private search. And I want to be clear here. There's the ESP and what they did. Then it goes to NCMEC. NCMEC sometimes opens or doesn't open. That's also in the report. Then it goes to the law enforcement. Then in this case, it goes to the county attorney and to Cynthia Nelson at Child Help. So there are various strata to this search that were not flushed out in the trial record, and that was not the defendant's responsibility. That was the state's burden to prove that the search was constitutional. Wilson was concerned about the record in that case.
Before you wrap up, can you give your best argument as to why this is a 4-person case that I was referring to earlier, not a 2-person case? Yes,
I think the state can't ignore facts that complicate probable cause. That comes from Cisco, the medical marijuana case, where some people have, the right to use medical marijuana, other people are holding it illegally. That you have to take kind of, you can't bury your head in the sand about facts that complicate your probable cause analysis. I think the same is here with digital evidence and digital membership. The law enforcement can't kind of do business as usual in historical precedents. They need to determine the contours of who's living at the house, who possibly has access, and build that investigation before honing in on one person.
Thank you, counsel. Thank you both for your helpful arguments. We will take it under advisement at this time and issue a decision in due course. And we're not adjourned, but we're going to vacate to let the next case come forward.